appeal in the matter of Sahara Energy Resource Ltd and another site.
Yes, Mr. Young. Mr. Hussain, I think you know we can't sit tomorrow morning.
I didn't know that.
Oh, no, I'm sorry that message hasn't gone through.
Is it only, this case only about is about the meaning of one word. I think we probably won't need the entire time.
Well, we'll see. Have you discussed carving up time between you?
No, I wasn't aware that it would be tomorrow morning, but at the moment
My lord, I think the indication we got, my learned friend might not have seen, is that you can sit in the afternoon tomorrow. Is that right?
Yes, we can.
So
We've
it's a
got
day
a day and a half, which is the estimate.
which is what we estimated.
Yes.
My lord, but thank you for that indication. It means that we don't have the dreadful queue outside the Eastern Bloc, which is the worst I've ever known it today.
Well, I'm sorry about that.
No, don't worry, it's not your
And there's a transcript being made, is there, or not?
I believe we're being live streamed, but I see nods to suggest there is a transcript, yes.
And that'll be provided to us with it in the evening. No?
No, I'm being told there isn't a
There's
transcript.
no transcript. All right.
When I say there's a transcript, I mean there's no transcript.
Well, it's helpful for us to know for our
Yes,
notating
yes, indeed.
purposes.
It has to be said that if there are any documents which would like to be provided in Word, such as, for example, the important clauses from the contracts, which are quite long on occasions, they will be provided if you ask.
Well, I always find it helpful to have in Word the judgment and the skeleton arguments.
We'll make sure, if you haven't got it, we'll make sure you get it.
Thank you.
If that's any help. Well,
Off we go.
may it please your lordships. I appear with Mr. Stephen Dew and Mr. Joseph Rich for Sahara Energy Resource, which is a West African oil trading company. And I should say that in anticipation of the desire from the master of the rolls that juniors should get an opportunity to speak, both of them will get an opportunity.
I'm very glad to hear that.
So am I, actually, for an entirely different reason. And my learned friend, Mr. Hussain, King's Counsel, appears for Snowden, who are an oil refining company which is substantially owned by the government of Cameroon. That's a not unimportant point, as we will come on to. This is an appeal from Mrs Justice Cockerill, with the permission of my Lord Justice Phillips. Now, I should begin by saying I am a very great admirer of Dame Sahara, but I am reminded of the dictum which amused the commercial bar back in, I think, about 1982, of Mr. Justice Bingham in the Catherine L, where he said, as Mr. Tomlinson almost told us, and Byron did, we learn from Horace, Homer sometimes sleeps. And I fear I have to say that on this particular occasion, Homer, in the form of Mrs. Justice Cockerill, as she then was, did sleep. She went off the rails, I'm afraid. Probably by over-reasoning. My lord, you will have seen the skeletons and seen that there are two basic issues. One, the true interpretation of the parties' agreement as embodied in the joint report, which was produced and signed following a two-day meeting, 2 long days, in September 2019. September 2019 was an important date because it was a matter of weeks before the expiry of relevant limitation periods. On any view, the parties reached a resolution of some disputes which had been developing over the previous 5 years. And I will call that issue, if I may, albeit pregnantly, the settlement agreement issue. And then the second, which is closely associated, is the effect of the Limitation Act upon Sahara's claims, largely, though not exclusively, if the settlement agreement is determined against me. and I'll call that the limitation issue. And I think when Lord Justice Phillips gave leave to appeal, he didn't necessarily think that was necessarily my strongest case. I hope I'll be able to bring a bit of light. I appreciate where I'm starting. It has two aspects, the limitation appeal. One is the true effect of section 29(5) of the Act. And I was slightly surprised that we didn't have it in the bundle of authorities. I've got it here if you want the whole of section 29. If you don't want it, I've still got it here. But
if you could provide it, and we'll slot it in later, but we won't take time about it.
Yes, yes, there's time enough for that. And the second thing is, arising under the limitation issue, is the true construction of the parties' indemnity agreements in clause 26 of their sale contracts, which relates to the accrual of relevant rights to an indemnity. Mr. Dew will address you on clause 26, and Mr. Rich will address you on the respondent's notice and my learned friend's argument that clause 8 is a liquidated damages clause, and in line, he says, with the eternal bliss on the marriage, that late payment is dealt with only by clause 8 and not by way of the indemnity. Notwithstanding the wording of the indemnity clause, it doesn't say. Now, as a prelude, could I make 2 points? One is that, in a sense, both issues involve the meaning and legal effect of parties expressly agreeing that certain enumerated claims were undisputed, expressly undisputed. In the settlement issue, the question is whether the description undisputed in relation to those two enumerated sums meant what it said and amounted to a settlement of the identified claims, leaving over the question of when payment would be made. And I'll come back to that because the involvement of the Cameroon government on when payment was to be made rather important. And the second issue is, if it did not amount to a settlement, the question still remains whether the description of the two specified enumerated claims, expressly described as undisputed, amounted to an acknowledgement of the claim under section 29(5), so as to disapply the limitation defence, which would otherwise have come into existence. The learned judge said that undisputed meant, in truth, disputed, and it wasn't an acknowledgement of the claim, therefore, and therefore these enormous claims, between 20, 70 and 120 odd million, were all time barred. The second prelude point is that my learned friend, Mr. Hussain, says that this case is very fact-heavy. I think when I looked at his skeleton, I think that point is made 5 times.
Well, she found that the FX claims
Yes.
were bad,
Yes.
and so you can only recover on those if you're right about them being covered by the settlement
Absolutely.
agreement. Is that right?
Absolutely right. Yes, and the reasons why she found the FX claim were bad, we did not think there was any proper ground of appeal. But your lordship is absolutely right. Whatever may have been thought in September 2019. Now, he said it was fact intensive. Now, and he relies upon the well-known judgment involved in Volpe, in which my Lord Justice Snowden was involved. And the only primary facts which the learned judge found were actually against my learned friend. I will show you why that is the case in a moment. But everything else is not primary fact. It's an inference, and in truth, when one reads the judgment, it's a construction of the joint report, admittedly against its context, and I will address your lordship on context. But the only primary...
Sorry, forgive me.
No.
Perhaps we should get this out at an early stage. There is an important difference, isn't there, between an argument that an agreement means something, which is an argument of construction or a written document in relation to which the admissible surrounding fact is quite limited.
Correct. And
an argument that an agreement was not intended to have binding legal effect, in respect of which a great deal more is admissible. Indeed, the whole of the negotiations before, during and after. And the judge in this case seems to have found that the claims were not claims you could sue on, claims 1 and 3 by reference to the 2019 joint report on both bases. Is that right?
no. Not for me to disagree with anything that you say, but when you look at the judgment, it's all based upon the construction. She said, undisputed is an ambiguous term. We'll come to it. I've got to take you through the joint report. Undisputed is an ambiguous term, and further negotiations has only one meaning. She's actually inverted the notion of ambiguity. But I would respectfully suggest that it was an agreement which was intended to have legal effect, and she didn't say that it wasn't. But I would agree with you entirely that she did look at the both the admissible and the inadmissible background. And I will show you on one very important bit of the arguably inadmissible background, namely as to how the document came to be drafted as it was. The learned judge rejected my learned friend's case, and it actually shows that the parties gave great consideration to whether the relevant claims were disputed or undisputed, and actually moved them from disputed into a separate section of undisputed.
When we come to your submissions, at least, we should be looking at it through the prism of construction and admissibility only to the extent admissible for construction.
I'm fairly unworried by issues of admissibility.
Well, you may be, but we're
You're not, no, obviously. But I will. I'll show you. I'll show you the, as I said, the previous draft, which generated.
Why?
Because my learned friend relies upon it.
Well, if we get to that stage, we'll see whether.
My lord, I'm just really trying to identify at the moment. I have very clearly the point that your lordship is making. But when you look at the judgment, it's a construction of further negotiations and what she thought that entailed. But I will mindful of your lordship's question. I shall come to.
Have I read the judgment starting its analysis? Starting at 126 on page 115 of the court.
Yes.
She is considering, in the first instance, whether or not the joint report is a legally binding agreement. There are indications that it encapsulates or at least contains an agreement which is intended to have legal effect.
Yes. Yes.
And my understanding is that she goes through points, as it were, in favour of it being a legally binding agreement. Then addresses countervailing points as she sees it.
Yes.
But doesn't seem to express a concluded view at that stage. Then goes on to look at what undisputed. But her conclusion seems to be at 140. The parties reached a limited agreement only,
Yes.
and that agreement related only to principal and contractual interests.
Yes. Now, if I may just pause there, they did reach an agreement, therefore. The question is what was embraced within the agreement, and that's a matter of construction.
Well, I think that must be right.
I'm
But the
grateful.
But the judge seems to be praying in aid some uncertainty as to its status as an agreement in reaching the conclusion that what is recorded about undisputed isn't an agreement.
Yes.
Because
And that's a matter of construction.
because she says at 132, the position as to an agreement on the undisputed claims becomes more difficult. The reference to this agreement, the submission that the reference to this agreement is determinative, cannot stand when, etc.
Yes, I'll come back to the words.
So
And she concluded, to be fair, at 146, she says it was an agreement to agree.
Yes, and she puts agreement in inverted commas.
Yes, and I will. What would have been more helpful is if the learned judge had reflected expressly upon Panyan and Feed products, which was a case which I relied on quite heavily, which your lordships may remember, and where Mr. Justice Bingham came up with the magisterial phrase that the parties are the masters of their own contract.
Contractual fate, yes.
Contractual fate, yes. Right. And I will show you what they were producing was, they described it as an agreement. And it was an agreement which was to serve a particular purpose of freeing up money from Sahara's bankers so that Sahara could perform certain provision of refined products, and money from the Cameroon government, which was otherwise not going to be available to Sahara, so that they could pay Sahara to get the money, get the fuel released. So
on the face of it, there is a clear recording. It's that agreement for the moment, recording that certain claims are undisputed, and that is between commercial parties. It's signed, sealed, and delivered. Maybe not as a deed, stamped, and it seems that the only thing in the document which could lead one to believe that it is not a conclusive agreement, that those sums are due and owing, is the reference to further negotiation.
yes,
And in that, what you say about that is the judge's own summary of what that clause said shows that she didn't give it its proper. She didn't recognise that what was actually being talked about there was discussing payment schedule.
yes. And if I could just be absolutely frank about this, payment schedule, or if the Cameroon government came back saying, no, you're not going to have all of this money, you can have X percent of it, then there might have needed to be certain negotiations by way of renegotiating what had been agreed. As we did, nobody knew what the Cameroon government was actually going to say in response to being provided with this joint report and the documents which had already been provided and were acknowledged as having been provided as supporting. So I wouldn't say that the further negotiations is limited to when payment was to be made. It might mean we may need to come back to this. What we've agreed is undisputed if the government says you can't have all the money.
But you're not saying that it could be. What you're saying is it was agreed it's undisputed. Whether or not it would be paid might be different.
Absolutely, absolutely. Not only whether it would be paid, but in particular when it would be paid, or when some part of it would be paid. I'll show your lordship the undisputed, I may use that term, the undisputed background, the context, to make this good. But yes, I mean, further negotiations contemplated that there would need to be something agreed about getting the money to Sahara as best they could. But masters of their own contractual fate, that was something that might come along later, as was the agreement about demurrage and dispatch in energy products. So there was an agreement. The parties agreed to call it an agreement. And what was important was that it was an agreement which was to be provided to Sahara's bankers and the Cameroon government. And you're thinking, well, why provide them with an airy-fairy agreement to agree?
But I thought your point, which seemed to me to have some force to it, is that there's a distinction between the provision to your bankers, which might be regarded as some form of condition,
Yes.
their approval, but there's no such provision in relation to the Cameroon government.
Absolutely right. And the learned judge said she thought, and I will come to this when I analyse her judgment, she thought that the Cameroon government's agreement had to be given in order that Sonara could agree his claims. And I say, no, that's precisely not what the joint report says. It refers to the agreement of Sahara's bankers as effectively a condition precedent, but it makes no comment at all about the government of Cameroon as a condition precedent to the agreement. And the expression of the one is the exclusion of the other. One might be persuaded that if they say that the agreement of one banker is a condition precedent, but they don't say the agreement of the other banker is a condition precedent, then the agreement of the other banker is not a condition precedent.
It would certainly help me if, when you're making the submissions, you could actually either stick to interpretation or indicate why you say that the background type you've just been dealing with is either relevant or irrelevant. Because, for example, on the point you've just made, you've blended, if I may say, questions of contractual interpretation in the conventional sense of looking at the words that are used, and you say expressing one excludes the other, which is a perfectly legitimate and well-known contractual interpretation technique. But then you've drifted into something which might be said to be extraneous evidence, and it's particularly significant because, for example, at paragraph 139 of the judgment, on the very point you've just been dealing with, the judge said in the middle of 139, then there is the fact that the parties knew that the Cameroon government agreement would be needed for anything not demonstrably, whatever that means, due from Sonara, particularly in light of etc. etc. Now, I'm struggling at the moment myself to disentangle both in the judgment and this section of the judgment, which looks like it's supposed to be contractual interpretation, to disentangle contractual interpretation in the sense I'm familiar with background material which you're sort of weaving in when it suits you and then dropping when you don't.
My lord, if I may say so, your lordship is absolutely right. And I am going to go through the document and then go through the background. I'm going to try and tether the two. I was really just trying to respond more holistically to the point made by my Lord Justice Phillips, and in particular about the ambit of further negotiations. But the point that your lordship makes is a very sound one, and I will keep it well in mind, and I'm going to take you through the document.
Because I think your main criticism of the judge, if I was to stand back, is that by adopting what might be said to be a quite holistic approach, the judge has deviated from the normal principles of contractual interpretation.
Yes, that is it. It's we're all told, look at the words used by the parties, and undisputed is undisputed, and it does further negotiations make undisputed become disputed. And that's, I would say, it's not a black acre and white acre point. It's when the parties agreed something was undisputed, did they actually mean it was disputed? as a matter of construction. So, but the point the Lordship makes about keeping the two discrete, I will endeavour to respect, and I take you through the material. Your Lordships have obviously all read very considerably into the case. Can I just take you to the joint report in the light of the point made by my Lord with Justice Snowden, which is in the supplementary bundle at tab 7, pages 263. And if I can just, it's
So which page?
C263. Sorry. One of the initials has gone ahead of page number.
Sorry. Page. Sorry, I'm just completely baffled as to what you're actually taking this to.
Ah, I'm sorry. I suddenly realised what I've done. I had actually transposed from the original trial bundle. So it's page 45. I'm a fool. Sometimes when one's worked on a document, one tends to transpose it. It's page 45. It's a joint report of a reconciliation meeting. I will show you in a little bit what the parties' view of reconciliation was. For the moment, they call it a reconciliation. Held on the 4th and 5th. And they mark the attendees as those of Sahara and those of Sahara. You might just like to notice that the third attendee, Mr. Tanya, and the sixth, Mr. Musonji, they were both from the legal department of Sahara. So they had two lawyers there.
And Mr. Tanji was head of the legal department.
He's head of the legal department, yes. One of the attendees who is not named, but it's common ground, did attend briefly, is Mr. Jono, who did sign it. We see that at page 49.
That's something the judge didn't record in the judgment.
Correct. But it was common ground that he signed only 10 or 11, I think the only question was whether it was 10 or 11 days after.
She recorded that he signed it, but she didn't record
It was later.
that he ascended and
No, well, ironically, she sort of does, but not in the right place. But I'll show you, Lordship, how that is. But he was regarded as the decision maker. That was Miss Mzeo's description. He was the boss man, and his signature, when he wasn't marked as an attendee, is a matter of considerable importance.
His signature when he wasn't marked as an interview. So who are we talking about?
Mr. Njono.
So he's not in the list at page 45.
He's not in the list of attendees.
But he's top of the list of signatories at 49. Is that
Correct. Yes.
you're the director?
Left hand column, top signature.
And who put the seal on it?
I think. I don't know. Wait a moment. I think mostly when I say this from memory, when Mr. Njono signed anything, he stamped it. But I would need to look at an earlier draft.
I mean, I thought one point that was made is that if it's just a sort of memorandum of attendees of a meeting, you wouldn't expect somebody to put a corporate seal on it, but if you are actually trying to bind the company,
Yeah.
it's the sort of thing you might expect to happen. That we would normally expect somebody who has got charge of the corporate seal to use it to bind a company. Is there anything in the judgment?
There's nothing in the judgment, And I don't remember anything in the evidence either about who
Did anybody sort of, this was not a point that anybody stated one
No.
way or the other.
No. We were more concerned that Mr. Ngeno signed it. I mean,
Because he was the
he was the
Director General, and the evidence was that any agreement would need his approval.
Yes.
And I mean, to be fair, the seal has in the middle of it, Director General.
Oh, well, yes, yes. Your Lordship is right. So it does look as though he attached his imprimatur. But I don't think there was any significance at the trial. There was no significance attached to the significance of the
Right.
ceremony. I must be fair about that. But the point was that he signed it later because he was the important decision maker. And as I will show you, the previous reconciliation meeting was adjourned because the Director General was not present. He came along at the beginning of the second, encouraged everybody to reach a quick resolution because of the problems created by the fire and the lack of money. He then disappeared, and then he signed this 10 days or 11 days later. He didn't give evidence, but Miss Nzo did give evidence, and there was some debate in the evidence as to whether she told him what was meant by undisputed. There was no document showing that that happened, and the learned judge didn't accept her evidence.
So insofar as you rely upon his saying at the beginning of the meeting that everyone should reach a swift agreement, that's something you take from the evidence, not from a finding of fact by the judge.
Well, I take it from the evidence, but there is a modest finding of fact in a different place. Can I just show your Lordship that? It doesn't occur in the place where one would naturally have expected it. But if you look at page...
Sorry, when you do that, I think a moment ago you said that everybody knew that Mr.
Njonu.
was the decision maker, I think is the word.
That's the way Miss Nzo described him.
Is that transmitted into the judgment? So is
No.
it finding of fact?
Not in the judgment, but that's what Miss Nzo said. And
So what do I do? Do I write it down and sort of pay attention to that, or is that just a flourish?
no, you should write it down as being a matter of great importance. It's not just a flourish.
There's no finding of fact. Then.
There's no finding of fact, but that was the evidence. And the finding of fact was that the January reconciliation meeting was postponed so that the general manager could attend.
Yeah, no, I get that.
So it's in a sense, it's not a primary fact, but it is an inference from the other facts. I'm very...
Sorry, it's just the corporate lawyer and you just can't suppress it. It just bubbles to the surface occasionally.
I'm delighted to have your Lordship.
Most people aren't, but
Well, I am. Yes, but it was thought that the managing director, the general manager, was required. He was regarded by Sahara as the decision maker. If he had not given his imprimatur, it wouldn't have happened. And he did, and he did it 10 days later without being given any documented account of how undisputed actually meant disputed. So he signed it, I think, just with the document in front of him. The document was then provided to Sahara's bankers and to the government, or possibly to the government of Cameroon, and some suggested it wasn't provided. But nobody ever had any qualifying document saying that undisputed meant disputed.
And none of that is admissible as to construction, is it?
No.
I mean, it's just basic Lestrange and Graucock, isn't it? I mean,
It's just...
it's basic Lestrange and Graucock. If you sign a document containing a particular clause, you're taken to have agreed whatever it means.
Yeah, absolutely. Yeah.
So what does it matter whether he was told anything about what somebody else thought it meant?
Well, it matters in the sense that well, can I show you? I'm getting rather out of my my preferred route, but I think it's probably quite important for you to see the re-amended defence and counterclaim.
Sorry, can I just pick up
Yes.
what we do have by way of findings in the judgment?
Yes.
42, a reference to the position back in January,
Yes.
which was when the then General Manager
He was just about to leave.
was going to need to be present. And then we get
Mr. Njone then became General Manager in January.
when we get to 69, which is our September, Paris 69. 68, so, sorry, yes.
68.
Well, it's not listed as attendee, it's common ground that he did attend. He attended, although not the finding that you say reflects the evidence that he'd said it was necessary to have a
No.
swift resolution, and that he signed off on the
No.
69 again.
That's where I say that she gives an account of what was said. A rather truncated account of the 7th of September email, which she quotes at forgive me.
83.
Yes, 83. But what she does, she didn't refer to the quick resolution until she gets really rather as a postscript to her judgment, para 145, page 118. The 4 lines down, up from the bottom, there is the fact that the document was never drafted or signed off or as a settlement agreement, nor was there any internal report at Sahara of agreement. Well, actually there was.
Sorry, I've lost you.
So
Sorry, my lord, it's page para 145 at page 118.
at the very bottom of the page,
Bottom of the page.
there is the emphasis on continued trade and approval, with Sonara's GM saying at the beginning of the meeting he wanted a quick resolution in a bid
Yes.
to allow. So that is a finding.
That is a finding. Yes, it's just
what was said at the beginning of the meeting.
but she doesn't regard that as being significant when she looks at what she calls the likelihood or unlikelihood of Sahara agreement. And I just say that her eye was off the ball.
I mean,
But there is a finding
is
there.
any of that admissible if we're interpreting the document?
If we're interpreting the document, it's not on the wording of the document, but is it part of the admissible context? I would say yes, it is.
What statement said at the negotiation meeting?
Before the meeting,
So whenever you're interpreting an agreement, which you say is reached at the meeting, you have evidence from all the parties as to the to's and fro's during the negotiations at the meeting. That's not what I generally understand.
no, it's what I'm saying is that further negotiations is capable of all sorts of meanings. One needs even post Arnold and Britain and Wood and Capita, one needs admissible context. And what we have at the context is that Sonara wanted a quick resolution, as indeed did Sahara.
And you say as a matter of construction, that makes it less likely that a reference to further negotiations would be further negotiations which weren't further negotiations about whether there was to be, the matter was reconciled.
Yes,
put it that way.
you shouldn't regard further negotiations as kicking the can down the road. It's negotiations that might need to be made if the operation of the contract.
I understand you're saying that Sahara's general manager sort of pitched up and said he wants a quick resolution. Was it the finding that that was the common?
Oh yes, we were desperate.
And where's the finding of? Is there a? I mean, I understand that if you have a common understanding prior to the formation of an agreement by something known to both sides, then
65. This is or rather going back to 63, 64, 65. It expressed the growing urgency of the situation since its bankers were becoming more pressing and threatening.
but each side has something which is pushing them on.
Correct. But they've each got an interest to get a quick resolution. The interest is caused by a different impetus, but yes.
And in each case, their own view as to the urgency was expressed to the other.
Absolutely.
65, Sahara expressed its
Yes.
growing urgency, and it was said at the beginning of the meeting. Was said at the meeting.
And it was common ground that Sonara could not finance this arrangement. They needed the help of the Cameroon government. And that was put to my witnesses that they knew that Sonara didn't have the wherewithal, and it was the evidence of Mr. Zoe. So yes, it was common ground. But as a result of the fire, they were very, very short of money. And I think my learned friend cross-examined a number of my witnesses on the basis that they knew that they weren't going to get any money without the government of Cameroon coming up.
My understanding is that these contextual points being what they may, at the end of the day, you say undisputed is undisputed.
Yep, absolutely.
And you can't negotiate over something that's undisputed in terms of whether it's disputed or not.
Yes, exactly.
But so I'm not really sure where this context gets you, because you're back, and it seems to me you're very firmly placing your argument on the words. And really, it's in a sense, it's for Sonara to try to possibly refer to other matters to show that undisputed doesn't mean undisputed.
Not only doesn't mean undisputed, but means disputed.
But that is the converse, and you do indeed have another heading saying disputed, and we also know that things were moved between one and the other. That may not be.
That may be, but we know that they ended up.
What more really do you need to say about it? I mean, you need to look at the clause which refers to negotiation, but what you say about that is very straightforward.
Yeah.
That it's primarily looking at payment terms. It may have been looking at not only when but whether some will be paid and when, given the government's input. But that's it, isn't it?
Yeah, that's
so
it.
What do we do?
Well, we're going.
I'd be very happy to sit down with that, Michael, but I don't think I'm doing you any favours.
You were taking us through the agreement. It's my fault. We got diverted slightly by reference to what Mr. Njonu had said at the beginning of the meeting, and I took you off course.
I was. I'm here, my lord, to deal with the points that your lordship want me to deal with, and I've always taken that view, and it's my intention to do so today. I've got, in a sense, I started with attendees, and then I said, just please note that one of the attendees was not Mr. Njonu, but he signed it, and as my lord, Lord Justice pointed out, attached his stamp.
Yes.
There were two lawyers there, and everybody attended from Sahara. I think all save one gave evidence. Those from Sonara, only Mr. Zoe, who's the second entry, gave evidence. Mr. Njonu didn't. And I did ask whether all of the others were available, and Mr. Njono now works for a different Cameroon government, but everybody else was available but didn't give evidence, but the learned judge didn't draw any inference. But there we go. Now the agenda was reconciliation of the 2013 outstanding on principal, then reconciliation of 2013 crude transactions, contractual and late payment interest, incremental interest, penal charges, and forex differential. So all of those disputes are there. And then the third is not an unimportant one, payment schedule and agreement. And then execution of the product crude swap contract. You will see that the parties also made some quite detailed agreements as to the crude product swap, which also cast light on the rest of the document. I'll show you that in just 1 minute. Then any other business, and then outstanding on principal, 8 million. That was an undeniable fact. Then there was, going over the page, reconciliation claims, reconciled claims. They were, in the first two, in relation to 2013 contracts, and in the last 3 of those 5, they were under the 2014, 2015, 2016 contracts. And these were really just effectively abacus operations, looking at the numbers. When was such and such paid? When was it invoiced? When was it paid? When was it due? What interest is due? So it was a simple mathematical.
Is that right for late letter of credit penalties for 2014 and 2015?
Yes. Well, yes. I don't think anybody really wearied themselves because all of these sums were paid, but they were still, yes, it was still an abacus arrangement. But for the moment, I take my learned friend's point that the parties differentiated reconciled claims with undisputed claims. But then we have the important item 3, undisputed claims, which my Lord Justice Phillips says what it is. I think it's important that you should look and see what's on the right-hand side of that box, which is nothing. There are no comments. And in contrast to the disputed claim, there are no comments there by way of exposition or explanation. And there is no provision there for the time of payment of these sums. So there are two gaps. One likes to notice it. There's nothing to colour undisputed claims, but there is something possibly as to the timing of payment. Then we get to the disputed claims, which is on the following page. And that's the penal charges. Now, the banks were absolutely communism, as we say. The penal charges were on top of everything else, and they were effectively penalties, and they were quite significant sums. In the event, I should say, they were negotiated down with the banks, but at the time in question, and they put it 50,760,000. Now, then we've got a comments box. So it looks as though when there is something that requires a comment, the parties can introduce a comment. And the comments are, these figures were presented by Sahara, backed by supporting documents, and Sahara acknowledged receipt. Sonara communicated her understanding of Sahara's position and rejected the claims of the penal charges. So not only do we have undisputed and disputed differentiated, we've also got a positive rejection, expressed statement of rejection in relation to disputed claims. But that outright rejection was supplemented by a further agreement. The parties agreed to jointly contest the penal charges with the banks. So what Sonara were doing was saying, we reject these claims, but we agree to go and visit your banks with you, Sahara, to try and negotiate them down. Now, one might wonder why they were going to do that if they didn't think they had a liability, but it shows that the parties, when they wanted to introduce a qualification, they could do, and a comment, they could do so and did do so with some detail. And then we've got the resolution. All relevant supporting documents of the claims have been submitted by Sahara and duly acknowledged by Sahara. I think it's just worth noting all relevant documents, supporting documents, there was nothing left over. And then Sonara would review and collate the documents for submission to the government of Cameroon. There we have the statement that the government of Cameroon has a role to play. And then Sonara completely rejects all penal charges and requests a waiver of the same. So on 2 occasions, when there is a dispute, they say it's rejected. There is nothing about rejection of the undisputed claims. Then Sonara will communicate a date within 2 weeks for the parties to reconvene. Sonara to propose, and these are important words, potential flexible payment terms, schedule, and further negotiations on the undisputed claims. And when the learned judge recited that resolution, she had an ellipsis for potential payment terms and schedule. So the very issue of the majority, at least, of that resolution, which is when payment is to be made and how it is to be made, was omitted from her quotation. And I say, Noscitur Arsocis, I can't remember how that translates, birds of a feather, I suppose. Noscitur Arsocis, it is looking at the mechanics of payment. And
the payment terms and schedule presumably have related not only to the undisputed claims, but also to the principal and the reconciled claims. Because there's no dates for payment of those are specified in this document.
It rather depends, as a matter of language, on the undisputed claims, may govern all of them. If I may just, as a bit of background, once again, I'm aware of the point made by Lord Justice Snowden. The problem for Sonara was that they had certain debts in their books. Those were the debts that were actually those reconciled claims. What they didn't have in their books was the other claims, so they needed to be dealt with separately. And I'm very anxious that I'm not overstepping the mark here, but your lordship asks whether the payment terms would apply to the reconciled claim as well as the undisputed claim. All I say is that there's an ambiguity in that resolution.
Well, there's nothing in this agreement which shows when something in the order of 35 million euros and $5 million will be paid to you.
Yes, you're right.
And there is then a resolution referring to potential flexible payment terms. On the face of it, that would seem to cover payment of all this.
My lord, yes.
And that would then this is just testing the point out, because obviously that would then suggest that there is something further about negotiations on the undisputed claims, which doesn't relate to the principal and the reconcile.
I would accept that that is one reading. There is then the question of whether it was, as it were, a negotiation to reach a concluded agreement, or a renegotiation of an existing agreement embodied herein. So there is an ambiguity in that resolution. The learned judge thought that it was clear. So
Clear that what?
Clear that further negotiations meant there would be further negotiations about clause 26 and clause 8.
Yes, but but she didn't address what proposed potential flexible payment terms related to.
She didn't even quote it. And that's why I say you go back to the gap in the undisputed as to when payment was to be made. And clearly the parties had not got agreement as to a specific payment date or dates, the method of payment. But then I come back to Panyan and Feed Products and the masters of their own contractual fate. They were leaving that over until they knew whether they were going to have money. But when they were going to get it from the government. So I would entirely agree with you, my lord, that there are several ways of reading that fourth resolution.
What do you say it means? I mean, sorry,
I say it means they will meet again within 2 weeks. Sonara will convene a meeting in 2 weeks, and they will discuss the payment terms, payment schedule, and anything else that needs to be discussed about how to effect payment. And if
Of what?
well, I say the undisputed claims and the reconciled claims.
And the reconcile.
And the reconciled claims. It's not exquisitely drafted, I would agree.
But do you say that undisputed claims there includes not only category 3, categories 1 and 2, which have been put as outstanding principle and reconciled, so that actually the negotiations are to be on all the matters that are not disputed, and that's
Yes.
why it's to be interpreted as payment schedule.
Yes, my lord, yes, I have some difficulty in saying that where they've used undisputed claims in one place, they use it in another. They're referring to the undisputed claims, but reconciled claims are also undisputed. So if it's capital U, capital C undisputed claims, then it's one thing. But if it's little u, little c undisputed claims, then it's everything that they don't dispute.
Yeah.
But it was about agreeing what was to be paid when.
well, yes. I mean, as I understand it, what you're actually saying is there had to be a discussion about how much would be paid when.
Yeah.
The flexible payment terms and the scheduling, which I assume means of payments.
Yeah. Yes.
And that the further negotiations would be about that.
Yes. Because
rather than the principle
Yeah.
as to whether the undisputed claims were actually disputed.
yes, we're still. I mean, the way that it is put by my learned friend is that there was a dispute about clause 8 and clause 26, which I can't know at the moment. That had been lingering on consistently for 2 years, which in one sense was entirely true. And that dispute was still left for further negotiation.
Where does this agreement contain any reference to agreeing the payment of the category 1 and category 2
It
provisions,
doesn't.
the principle of the reconciled claims?
It doesn't refer to the It's, as I say, my lord, it's not an exquisite draft, but probably late on the second day. One's all too familiar with how mediations go.
Well, it may not be very surprising that that hasn't been agreed, because the documents are all going to be submitted to the government. It's recognised that it's dependent on the government for funding, and then they're going to come back in 2 weeks' time, presumably on the hypothesis that the government will have had a chance to respond within that time.
Yeah.
To do whatever is the scope of the final bullet
Yes.
point,
And it's,
which is what we're
the government's going to give us 30 million next week, and we can pay you next week, but it's going to give us another 100 million in 2 months, so we'll pay you in 2 months. Or the government says we can't afford to give you all of this, we're going to give you 100 million overall. And yes, one doesn't know, but it's, I say further negotiations is just the sort of thing which was contemplated as being left over in Nationale and feed products. Is if the government says no or later, then that will have to be the subject of further debate within 2 weeks. I think that's the way I put it, my lord. As I say, it's not an exquisite piece of drafting, but I hope it encapsulates the sort of things that are contemplated by that fourth resolution.
Well, at the end of the day, in a sense, all that you need to say and do say is that whatever it means doesn't mean this undisputed, doesn't mean undisputed.
It doesn't make undisputed mean disputed. And one has to say, my learned friend, the learned judge says, well, undisputed is an ambiguous term. Well, it isn't. If it's disputed as to liability but undisputed as to quantum, it's disputed. If it's disputed as to liability, sorry, if it's undisputed as to liability but disputed as to quantum, it's disputed. It's only when it's not disputed as to either. It's not an ambiguous
So
term.
we come back to your case being very simple.
Yeah, absolutely.
On this point.
I like to think it's always been simple. The learned judge sort of made it rather more difficult. Now, I wonder if I could just show you the last page, page 48, because it casts some light on the way that one should read this document. And this is the swap contracts, whereby Sahara were going to supply Sonara with refined products, because they couldn't find their own. And there were a number of ships that were available, which were provided. And when one sees them, the Zephyr, the Sydney Spirit, the Kirianos, and so on. Then we look at the bullet points at the end, and they are revealing as to the way that these parties referred to disputes. The Zephyr and the DSC Marine Direct Payment as per agreement is signed between Sahara and Sonara and DSC dated July. So that's dealt with. Second dot. Sonara dispute reject MT Sydney Spirit demurrage and insist balance on swap of 24 million. Sahara maintain claim. So they are very, very good at identifying when there is a specific rejection and a specific dispute. Then the Kyrinikos demurrage claim have been received and subject to validation. Once again, considered. Product supply schedule 25,000 tonnes gas oil, 15,000 tonnes jet fuel, subject to resolution of pending legal issues with Sahara's financiers. And that's the point, that they weren't going to get any of the refined products without Sahara's financiers giving the okay. So once again, they are capable of introducing detailed reasons for rejection and the fact of rejection of claims, and when they want to introduce a subject for a condition precedent, they could do so in clear terms. And then we see that this agreement, bullet point, this agreement will be submitted to Sahara's banking and legal partners for validation. So the parties were agreed that the agreement itself was an agreement, that it had to be provided to Sahara's bankers to make them happy, and there was no other document that was going to be supplied. So if undisputed meant disputed, because of a clever argument, it should have been made clear because the document itself was going to be presented to Sahara bankers and would otherwise have misled them. And then we get to the last page, which has got the signatures. And
So are you saying that, do you say that the words in bold amount to a condition precedent to the binding nature of this agreement?
Yes.
So agreement means actually not an agreement; it's a condition precedent.
Well, it's it's an agreement with a condition, whether it's condition precedent, a condition subsequent. I think it's for validation. I would say subsequent rather than precedent. Now you ask me.
Okay.
And one is familiar in oil trading with contracts made with subjects, which I'm sure my lords are very familiar. And if a subject is satisfied, then the agreement becomes binding. And if the subject is not satisfied, then it ceases to be. But it doesn't stop it from being an agreement. So that is the document itself, looking just at the words. They use clear language to describe that which is undisputed as distinct from disputed. The parties themselves were clearly aware of the distinction between the two and were prepared to embody their agreement. They knew how to stipulate a condition precedent or subsequent, and they said nothing in it about the when payment would be made or the methods of payment, because everybody knew that it had to go off to the government of Cameroon, and that's why the document had to be, and the documents had to be presented to the government. So I say that undisputed means undisputed, and however one cuts it, one can't turn it into meaning disputed. Simple point. I wonder if I could show you bearing in mind my learned friend's point about primary fact findings, if I could show you the one fact finding which was referred to primary fact finding. It relates to the plea put forward by my learned friend's predecessor at page 177, which is in the re-amended Defence and Counter. And this is my learned friend's feeding on the effect of the joint report. Although in the joint report the figure of 20-odd million incremental interest and the figure of 56-odd million FX differential appeared under the heading undisputed claims, it is denied this reflected an acceptance or agreement that those sums were owed by Sahara to Sahara, and for the avoidance of doubt it's denied that Sahara owed such sums to Sahara. Now, undisputed claims was a phrase used by Sahara to signify that the claims in question concerned sums which Sahara accepted that it owed to its banks, whereas the phrase disputed claims was used by Sahara to signify claims in respect of which it did not accept any liability to its banks for the sums in question. That is why page 3 of the joint report recorded the parties will jointly contest the grouping and charges. So the only case that was pleaded by my learned friend as to the meaning of undisputed claims was that Sahara said this is undisputed as between us and our banks. Now, and that's what Miss Nzo said in her evidence, and that was rejected by the learned judge.
That's not primary fact.
it's as close as one could get to a primary fact. If
What's an argument of interpretation?
well, there, well, the evidence of Miss Zoe.
You mean the judge rejected Mrs. Evidence?
Yes. But Miss Zoe said that Mr. Olengavi had said to her that that's what it meant, and that was rejected.
Just show us that in the judgment, please.
Um, 134, I think, is possibly. But I don't think. But that is rejected. It's not. There's no hint that it could actually mean that. And I think the learned judge accepted the proposition that once you had forex grains, it could never mean that. But that was the evidence. If it's primary fact, it was rejected, and if it's not primary fact, it didn't succeed.
She's rejecting that as a matter of interpretation.
I'm very happy that she is. I was merely showing you that the one potential area for primary fact and for evidence was in Ms. Zoe's.
See, at 135, neither of these approaches there was an answer which was going to arrive by objective to the result.
Yeah, well, yeah, no, you're right. But I'm merely saying that the only case that was pleaded was that.
Well, I know that you made the point a number of times in your skeleton, considerable number of times, that
Highly likely.
that the judge's ultimate interpretation of the words undisputed was not the instruction for which Sahara was contending, and this makes that point.
Yes.
I see that.
There is the other point that I probably make more often than I should, and that is that that particular construction must have been as to liability and quantum as between Sahara and Sahara's banks. So undisputed, even on their case, didn't distinguish between liability and quantum.
Well,
But
you
the
can
learned
make the
judge's
point.
conclusion was that it
You can make the point. You can make the point, can you, that the judge here says that there is not a hint that undisputed could naturally mean, and rejects that argument.
Yeah.
But you can equally say there's not a hint that it means undisputed as to quantum.
Absolutely, and as we've seen elsewhere with the appeal charges and the other demurrage charges, when they've got a particular point, they set out a commentary, and the absence of a comment is sufficient. So that's really it, Michael. I just wanted to show you the pleading point where really nearly all of the evidence went to that. There were some issues as to remoteness and the like, but that was the substantial dispute on the agreement. Can I, at the risk of wearying your lordships, can I just give you what I think are 11 undisputed background facts which may be relevant to construction as context? And I'm now moving away from the document itself to the context in which the document should be reviewed. And I hope my Lord Justice Snowden will. I don't think any of them. No, I know none of them is disputed. The first is that there is no dispute, but that Sahara serially breached their purchase contracts and were guilty of events of default for the purposes of the sale contract. The second is, there is no dispute that Sahara in fact suffered very large financial losses following Sahara's breaches. Indeed, the learned judge's conclusion on agreed to quantum rather suggests that is in dispute. The third is, there is no dispute, but that the parties had various meetings over the previous 2 years to reconcile their position on Sahara's claims. And I say this in fairness to my learned friend. There is no dispute but that Sahara had consistently relied upon the argument that clause 8 of the sale contract provided an exclusive remedy for late payment, and Sahara had equally consistently argued that clause 26 provided a wider indemnity. That had been a running debate, and I don't in any way seek to escape from it.
Is that point 4 or past point 3?
Sorry, that's all point 3.
So when you say the parties had meetings to reconcile their position, what you mean is what, to settle the dispute, or use the word reconcile,
Yes.
which is an unfortunate word to use in the current.
Perhaps I could show you.
Do you mean had the parties had meetings to discuss the position, actually reach a settlement, or attempt to reach a settlement, or just agree the numbers, or what?
Can I ask you to look at to see what I mean by it? The evidence of Miss Zoe, which is in the supplementary bundle, at page 161.
But is there nothing in it take us to in the judgment?
There's nothing in the judgment, but it's I'm doing this because it's actually it's just probably the most convenient way of showing you how the parties read it. But can I show you this, and then one of my learned juniors will find if there's anything in the judgment that I should be showing you.
161, did you say?
It's page 161 of the supplementary bundle. This is the evidence of Miss Zoe. And page 26 of the transcript. I ask at line 16. Now, what's the difference between what distinguishes a reconciliation meeting from something that is not a reconciliation meeting? And then answer. Business meetings. Meetings where maybe Sahara will come with a proposal for new business ventures. I see, yes. And reconciliation meetings are what? When you're trying to agree, are sums which are payable by one party to the other. Is that right? We're trying to evaluate the debt of the particular day. You're trying to agree how much is payable by X to Y, and when it is payable and how it is payable. That's a reconciliation meeting. Yes, that's it. A reconciliation meeting is about working out what is to be paid, when it is to be paid. Correct. That's the meaning of reconciliation meeting. I hope that answers my lord's question. If there's anything in the judgment, no, I'm told there's nothing specific, but that's how Miss Zoe regarded it.
But hang on a second. So I thought your proposition as a my heading is matrix, like factual matrix.
Yes.
Is that the parties had meetings to reconcile their positions.
Yes.
Yes. Are those the meetings that actually are referred to at line 10 in paragraph 14 of the witness statement? Representatives from Sahara also attended other meetings from 2014 onwards to discuss business between the parties more generally, but these were not reconciliation meetings.
Yes, that was her evidence, not reconciliation meetings. And then,
so where's the evidence that there were quotes reconciliation?
that is in the when in the judgment where the learned judge records merely page 98 and following of the bundle, going over February. It's really paragraphs 34 and 37 and then 41. Those were described as reconciliation meetings. February 17, September 17, January 2019. But there is no intrinsic magic in a reconciliation meeting, but it was a meeting to resolve a dispute rather than a meeting to do new business. and I'm trying to find neutral words to describe that. There is, this is the fourth point, my lord, there is no dispute, but that the last reconciliation meeting before the September meeting was held in January 2019, and it was adjourned. If I could show your lordships the supplementary bundle, page 449.18.
So supplemental bundle
49.18. Uh,
74.
74, yes. This is the meeting in January 2019, and the agenda was addressed, and then the technical director, Mr. Jean-Marc Yambo, started the meeting reading of the agenda, which was adopted following the presentation of all members present, with the insertion of 2 points, and it's 1. The DFC, Finance and Accounting Director, suggested that the point on Sonara's outstanding be moved to a later meeting where the GM will be present. Sahara concurred, but expressed their wish to give a breakdown of their actual situation and review all associated documents before the same meeting. So that was why the suggestion that it be stood over until the Director General could be engaged.
But coming back to your context points,
Yes.
that there'd been meetings for the purposes of reconciliation, what the judge found about this was that when it was scheduled, it was aiming, this is para 41, for a final position to be taken
Yes.
on the Sahara outstandings, and Sahara had made clear they expected to see a proposed outline schedule of payments.
Yes.
So your point is the January meeting had been intended to be what we would call a settlement meeting.
Yes.
Although in the event, at the meeting itself, that was put off because it needed the GM.
Well, yes, and in fact we know the Mr. Njonu became the Director General in January 2019. So there was an interregnum probably there. But the fact is, I mentioned the fact that Ms. Nzo said that the General Manager was important. If I can just show you page 168 of the supplementary bundle. Again, this is going to be quite short.
I'm sorry, I missed that reference.
Sorry, 168. This is in.
Thank you.
At 54 of the transcript, line 5. So the General Manager began the meeting by saying he wanted a quick resolution that could get the product supplied again. Do you remember the General Manager saying that? Answer that he hopes will come with something that will permit for the business to continue. Yes, he wanted a quick resolution. Because Sahara had to supply the product, they said they were not supplying before this meeting. Yes, he wanted a quick resolution, and that meant a quick resolution of the disputes which were existing between Sahara and Sahara. Would you agree? It was a quick resolution on the reconciliation of the debt, my lady. That was speaking to her. And then over the page, page 55, first answer at line 5, he said he wanted the parties to agree at that Sahara should start delivering the products under the swap agreements to finalise the reconciliation. Now, you will remember when I was asking questions about the January 19 meeting, it was thought desirable to adjourn discussions until the general manager could be engaged. Do you remember that? Yes, I remember. So the engagement of the general manager in the September reconciliation meeting was rather important, correct? It was important. General manager of the company, if you don't persuade the general manager of the company that a deal was good, then the deal was not going to be made. I couldn't persuade the general manager. And then line 3 on page 656. If the general manager is not persuaded, the deal would not be done. Yes, and if the general manager is persuaded that the deal is good and in Sahara's interest, then it can be done. Would you agree? The decision, he decides. That was the point that I referred to earlier, and I think I better make it good by showing you. He was an important chap. And I do suggest that is an important element in context of the matrix.
Well, if you didn't agree with you, if you turn the page, if you look at the last bit of the page, you put the points that both sides were wanted a deal. That's what everybody just lay. Would you agree? He says, I don't agree. We're not in a trade deal, we're in a reconciliation meeting. I mean, what do we get from this? There's a slight danger of sort of just dipping into the dipping into transcripts of evidence without findings in.
My lord, I am in entire agreement. It was just fleshing out a point that I had actually made earlier on, saying that he decides, and I thought it was right that I was going to make that.
We know that, in fact, an agreement was.
Yes.
We know that certain sums were described as undisputed.
Yes.
And we know that there was a reference to further negotiation.
And we know that Mr. Johnny.
The only question is, what does that mean?
Yes, exactly.
I'm not sure how the fact that somebody has said we need an agreement quickly, and then that's what resulted.
It goes to the point that's made by the learned judge that the unlikelihood of Sahara agreeing something that they didn't think, where there was still liability and dispute. Because actually, I'm sure your lordship, I don't know how many mediations you've attended. One is familiar with Mr. Russell, who he gets people together, they each state their positions of principle. And yeah, well, these issues of principle are all very well, but let's get down to the nitty-gritty. Where are your interests really lie? Put the issues of principle to one side, let's get an agreement. And that's, I would suggest that is, in a sense, what happened here. That Mr. Njonu says, I don't care what the disputes are.
But I thought, forgive me, but I just keep coming back to the difficulties. My understanding is you say that what we have to do is look at the document.
Absolutely.
To see what was agreed.
Yeah.
So I'm not sure why you rely upon this material.
No,
contrary to, it seems to me, you say the document's clear cut.
Yeah.
So why do you want to introduce?
Because my learned friend says further negotiations is what really matters.
I understand that, but I'm not sure why the preface to the meeting changes what was the outcome of the meeting.
It's only because the learned judge said the unlikelihood of them agreeing, without actually saying, well, both parties wanted a quick resolution. I mean, that's all. It is 3 stages down the logical process.
What are you trying to do there? Are you trying to challenge the judge's findings of fact? Or
No, absolutely.
I'm as mystified as my lord is as well as to why you're, as it were, being led astray
No,
by your opponent on this.
I'm absolutely not challenging the learned judge's findings of fact. I'm just trying to.
You've got an agreement,
I've got
which you say is clear cut on its interpretation. Why are we looking at 11 points of context, none of which at the moment seem to me shift the dial one jot in either direction?
My lord, because
maybe others, maybe the remaining 7 aren't.
For 2 reasons, really. One, because my learned friend said that you have to look at everything, and I'm just trying to show you.
Well, he will no doubt show us.
Yeah, he will.
And then you can reply.
And secondly, no, you're right about that. And secondly, because the learned judge referred to the unlikelihood of Sahara agreeing something which was just, and I'm just saying, actually, not entirely unlikely. And that's not a primary fact, but where she is any unlikelihood. It's an influence.
It seems to be common ground that they did agree something. It's only a matter of determining what they agreed,
Yes, absolutely.
and that seems to me to be a matter of looking at.
Yes, my lord. At the
And
risk of-
conversely, on your case, the fact that they both wanted to have a quick resolution was not wholly successful because there was some part of it that was not resolved.
Yeah, the penalty charge. But
Exactly.
what they did do was agree the way out of that one, which was to have a joint meeting with the bankers. So they even agreed the way out of that one.
Anyway, that's your third point of contact.
That's
Are we still on point 3?
no, that was I think point 4.
Yeah,
Point four.
I'm slightly perturbed because when my lord said there were another 7 points, I
No.
thought that we were going to have 8 because I've somewhere missed
Let me,
number 4.
can I just cast my eye over them as to whether any of them actually?
You said 4, and I can't figure out where 4,
Which was number
where
4?
3 ended and 4
Four
started.
started with the last one in January 1919 was adjourned.
Yes.
Which is then we looked at that, and then we moved on, still part of 4, as I now understand it, to the quick resolution point.
Well, that was my 5.
Okay.
Right, good. Well, there we are. We're steaming ahead. Let's, if we've only got
I
6
was-
left,
I was
let's
so
get on to them, shall we?
I was so unwise as to enumerate them at the beginning.
All right, number 6.
Was it
Uh,
fun?
No, number 5 was quick resolution. We've just been.
There is no dispute but that the Sahara were in dire financial straits as a result of the fire, and that they needed to buy the products which Sahara were going to supply if their bankers would agree. I'm going to go through these rather more. I've got references for all of these points, but I think I can probably take them quite quickly.
Why don't you give us the references but not take us to them?
Yeah, right, I will. Supplementary bundle 166, transcript 4546. The 7th point is there's no dispute that the September meeting was attended by lawyers. The 8th point is that there is no dispute but that the draft report was prepared at the end of the day, but there had been a previous one at the end of day 1, where all of the now undisputed were under the heading of disputed, and the parties rejected that. That's supplementary page 56.
Can we look at that? Do we look at that as a guide to interpretation?
I said you couldn't to
So
the
why
learned
you
judge,
asked-
but the
why
learned
you
judge
asked-
did.
Okay, but so was she right or were you right?
Let me put it this way, my lord. I say all you need to do is look and see how it ended up at the end of the day, and they split disputed and undisputed. So whether they had, and it was an intentional division. We actually know it was intentional because it was actually moved.
Because
But the answer to my lord is no. Okay.
so it's not possible.
It's not. I say it wasn't. I said it wasn't admissible at the time, and I maintain that. And there is 9. There is no dispute about how the document came to be drafted. Mr. Omofalarin and Mr. Mazo sat together with his laptop, and they were doing it jointly. There's no 10. There was no dispute that it was signed by everybody, including Mr. Njonu, who was later.
Well, it wasn't, was it? There's one missing.
Yes, Mr. Njonu signed it later.
No,
Oh, yes.
no, there's a missing
Mr.
signature.
Yes, he had left. He had left
Mr.
before the end. Of the
Takumi didn't sign it.
Yes, he left before the end of the meeting.
Neither did Mr. Materjo.
Yes, Mr. Mataja had left before the end of the meeting. I think
But why does that matter?
it doesn't. It doesn't at all. It doesn't at all.
So this is not in fact matrix or indeed relevant to
You're probably right. I'm trying to give your lordship a. No, you're
There we go,
absolutely
that's number
right.
10. No dispute that it was signed. Number 11.
And there's no dispute but that the document was to be shown to Sahara's bankers and the government of Cameroon. And it would be odd if a document which describes something as undisputed was to be shown to bankers without telling them, by the way, it doesn't mean undisputed at all. But those are,
That's not
no,
that's part of the agreement.
that's part of the agreement. My lord, I was trying to create or trying to establish a background against which your lordships can decide the case. I'm not saying, I say exactly what my Lord Justice Phillips has put to me, is that undisputed means undisputed. It's not a term which really deserves much of an exegesis. The position is that both parties had a real interest to arrive at a quick resolution. And there was no document explaining or qualifying undisputed. There's one point which is made by my learned friend. I think I had a complaint that it hadn't been suggested that it meant undisputed as to quantum, but disputed as to liability, and he's shown two sentences where the learned judge put that to me. What is important is that it was never put to any of my witnesses, nor was it extracted from Miss Zoe, but that's what it meant.
It wouldn't have been admissible, would it?
It
The answer wouldn't have been
probably
admissible.
wouldn't have been admissible anyway. No,
So
but I'm just
no significance in that then.
no. If it's only significant if my learned friend is right in saying this is all a question of fact.
So that's reply then, is it?
It's a yes.
Well, the judge's point is, as I understand, she says the word undisputed is potentially ambiguous
Yes.
or uncertain,
Which it didn't.
and that's a matter of interpretation.
Correct.
And you say it isn't. Undisputed means undisputed.
Yes, and undisputed certainly doesn't mean disputed. I mean, it's as I say, it's not a black acre and white acre where one can say, oh, well, we know exactly what it meant. I think even Lord Hoffman, in his pomp, would not have regarded undisputed and disputed in the same document as meaning disputed and disputed. I don't know. Your lordships have gone through the judgment, obviously, in considerable detail. It actually covers, I think, about 2.5 pages. If I can, in my skeleton argument, I have gone through each paragraph. So anything I say will be largely either repeating or only slightly supplementing what I say in my skeleton. But I will try to be quick. She recites starting at 119. She says this is a central factor in the case, and then says it's as this the most of the witness evidence was selected. The parties disagree with the meaning and effect of the joint report. So she herself, I think, essentially it's a matter of construction. Then she sets out the arguments. And 122, so far as the contentious matters are concerned, Sahara says the joint report, the document, doesn't refer to any of the 3 extant claims as being agreed. Well, that's absolutely right, of course it does. That doesn't. But it does describe them as undisputed. It doesn't include under reconciled claims, which now have the claims for contractual interest are separately recorded in the same document. Rather, it records that undisputed claims, claims for incremental interest and ethic claims, are to be the subject of continued negotiation. The word continued there is already a pregnant word. It doesn't imply that there was going to be a continuation of the same negotiation process. It's just that there would be in 2 weeks further negotiations, which is not the same thing. And Sahara rejects all penal charges. Accordingly, Sahara contends that Sahara's primary case is binding to pay the sums claimed for incremental interest and ethics claim is fanciful and must fail. as to the negotiations, Sahara does place more emphasis on these.
So just the end of paragraph 121, is that a finding by the judge that in relation to the reconciled claims, it did amount to a binding contractual
Yes.
agreement?
I think that's whether it's a finding of fact or a construction of the agreement.
I don't mind
Whichever it is.
characterise
Yes.
it, but that was what the judge decided
Yes.
in relation to the reconciled.
Yes, and that's not, and indeed, we know that those claims were actually paid, albeit after the time article. But yes, we want to discuss that. And then, as to negotiations, she deals with Sahara's case that you've got to look at all of the negotiations, and she refers to a passage in the judgment of Lord Justice Coulson about looking at all the negotiations. And it's that which led me to show you the, if you refer to, the draft which was subsequently amended in the joint report. I don't think that matters. We get to analysis. Well, 2124, there was therefore technically a debate as to the admissibility of the end of the negotiations. That parties' actions after the joint report was signed. That debate hinged on the question whether one was considering the question of whether the agreement was concluded, in which case the materials would be admissible, or whether the issue of one construction. She said it at least in the same conclusion. But that was in the sense why I was seeking to show you the factual background. The analysis. The starting point is the words. That's great. Yes, that's exactly right. Undisputed, and it's difficult to read undisputed than anything else. She says it's 127. There are indications the joint report that it either encapsulates or at least contains an agreement which is intended to have legal effect. Great.
She's considering the agreement as a whole, isn't
Yes, she is.
Not.
And undoubtedly, as I say, even as to the penalty charges, the parties agreed as to the way they were going to move forward, which was to have the joint meeting with the Sahara's bankers. That was the agreed way forward. Anyway, I don't think it matters.
There is a curiosity, which is the one thing she doesn't seem to, as you pointed out earlier, the one thing she doesn't seem to place any reliance upon is the fact that the general manager, several days later, actually affixes his seal and signs the document.
She doesn't mention that at all, and we would respectfully suggest that it was really rather important, given what happened in January. It was really rather important.
Given that he wasn't there at the meeting and therefore couldn't sign his signature to attest what was quote agreed at the meeting.
Correct.
It would seem to have a little bit more weight than she seems to have given it.
My lord, yes. Yes. Yes, if it was just a record of what had been said,
Allegedly.
then
I'll add the word arguably because
yes.
nephews
There
are
we go.
important.
And then the analysis, really, down to 130, she's pointing out the things that are in my favour. And she points out that whilst it wasn't a lawyered document, the parties had legally qualified attendees at the meeting. I'm not quite sure what you mean by a lawyered document, but it wasn't a sort of Clifford Chance 28-page belt and braces settlement agreement. I would agree with that. Then thirdly, looking at the boxes only, ignoring the resolutions, the impression given by the board statements of figures countersigned by the attendees and the titles reconciled and undisputed, the impression is that the document encapsulates an agreement in relation to everything except penal charges. Great. That's there you could stop, I would suggest, or should have stopped. But however, the initial impression has to be synthesized and the query has to be attempted to be resolved with the wording of the resolutions within the document, even absent the admissible background. A considerable doubt as to agreement on the undisputed claims is raised by the wording of Resolution 4, which she then quotes, but you notice she leaves out the reference to payment terms, flexible payment terms, and schedule.
But she's also now moving towards whether there's intended to be a binding legal agreement in relation to one aspect of what's in it,
Yes.
namely the undisputed
Yes.
claims.
What parties have
Rather
agreed
than,
to be
rather,
called
rather than whether it's intended that the document should have legal effect at all.
Yes, absolutely. Yes, they're carving out, they may be carving out from the legal effect of an undoubtedly an agreement which is intended to have legal effect and to be shown to bankers and government. One particular issue which hasn't got any comment, unlike the occasions when there is a dispute. Your audit is right. And then once, the fact that she quotes the resolution without quoting the words leading up to further negotiations is not, if I may respectfully say so, particularly helpful, because the indication of what further negotiations will engage is to some extent to be derived from that whole resolution. Accompanied, she said, by a query as to the involvement of the government of Cameroon, which is specifically referenced in Resolution 2 as an entity to which the document must be submitted. So everybody knew that the government of Cameroon were going to have to be providing such funds as they wished. Once the unarguably admissible background is brought into play, the position as to an agreement on the undisputed claims becomes more difficult. For Sahara, the submission that the reference to this agreement is the very final bullet point is determinative because there is no language confining it to parts of the joint report, cannot stand. So it's not just, it's probably wrong, it cannot stand. And she says it cannot stand when, as noted, this is not a formally lawyered document. I'm afraid, with the greatest of respect, I have great difficulty in understanding that point at all. Commercial parties are very good at producing agreements that are characterising what they've done as an agreement. Two, on any analysis, the agreement could only ever extend to parts of the claims, not the disputed claims. Yes, that is true, but they agreed how they would deal with it. They would make a joint approach to the banks. So even there they had an agreement. It just wasn't an agreement to claim. And three, the parties, despite having lawyers present, didn't call the entire document agreement or settlement agreement. They called it a joint report. So I have such difficulty understanding why, if the parties call a document an agreement in capital letters, which is to be provided to rather important third parties, that they don't mean what they say, whether it's lawyered or not.
Well, what I find difficult about this is it's unclear how this relates to the issue of whether this is a legally binding agreement at all. All these points seem to me are general points about the agreement,
Yeah.
and how it relates specifically to whether there's a legally binding agreement in relation to the undisputed claims. And what the judge seems to be saying is, well, I accept it's a binding agreement in relation to the first two items, but because there's some uncertainty as to its status as a binding agreement, it can't be a binding agreement in relation to the third.
Yes.
And I thought the analysis, once you accept that the parties intend the document to contain a binding agreement between them, it's then a matter of interpreting that document to determine what they have agreed.
Absolutely.
And it's perfectly possible that parties within a binding agreement might have made certain provisions which aren't intended to have legal consequences.
Yes. That would be entirely possible, and that's where we have the Hannah v. Pollux point. But as I say, the even as to the disputed item, the penalty charges, they produced an agreed way forward. So even that was an agreed that they would all attend and try and persuade the banks to see the error of their ways, which in the event Sahara did on their own and did succeed up to a point. But to suggest that the parties agreed characterization of the document as an agreement, that it cannot stand, I would suggest the learned judge was putting it far too high. And then at paragraph 133, nor do I accept the submission that undisputed means only one thing. Stripped of all context, it does indeed purely suggest a purely binary answer. But in a context where, one, there are two categories ahead of the disputed claims, two, both of those different categories suggest agreement, and yet are not taken together, and three, there had been two areas of discussion over the years, one as to the maths and one as to the liability, undisputed could very obviously mean undisputed as to liability, undisputed as to liability, undisputed as to quantum, or both. Now, I'm afraid I have remarkable difficulty, and I would submit the words very obviously simply cannot be right.
Sorry, just before you get to very obviously, can we just go back and unpick the earlier bits, because I'm afraid I'm struggling with the early bits. You said where there are two categories ahead of the disputed items.
That's reconciled and undisputed.
But there are three, aren't there?
Well, yes, there's the principal sum as well, yes.
Okay, so, right, okay. And when she said both of those different categories suggest agreement and yet are not taken together, does that mean that reconcile and undisputed haven't been taken together?
Yes. As a matter of...
But you've answered that.
Yeah.
You say reconciled means categories which aren't open to dispute as to liability.
They're just numbers.
Numbers, and undisputed is where there could potentially be.
Correct. And there had been, I wouldn't deny it, for 2 years there's been this debate about clause 26 or clause 8. But at the end of the day, and that was indeed how the email of the 7th of September.
Okay, so sorry, I distracted you.
No.
You were dealing with three.
My lord, it's simply that undisputed could very obviously mean undisputed as to liability, undisputed as to quantum, or both.
Will you simply say it obviously means undisputed as to both?
Yeah, that's what I say. It's
Right.
it's about as unambiguous a word as one could choose.
There's two areas of discussion over the years, one as to the maths and one as to liability. Do you have the references for that assertion? Where's the findings of fact that she's referring to? What is, I mean, barring the transcript that you showed us a bit earlier, which myself I found about the meaning of reconcile,
Yes.
reconciliation meetings or not reconciliation meetings. Do you have a suggested reference to what the judge actually means?
I think it's the findings which she makes at paras 34 to 45. My learned friend said throughout that there had been consistently a reliance on clause 8 by him and on clause 26 by me, which had never been resolved. He said that dispute carried on. So you say undisputed. Well, what's the light of that?
Well, you say that the Director General put his stamp on an agreement in which he said that these sums were undisputed.
Yeah, you've got it.
How many times can you go around this?
My lord, were it not for the fact that the learned judge, who is a jolly good judge, concluded that
Well, she
the
may be right or
opposite.
she may be wrong, but your case is clear,
Yeah, absolutely.
and you said it.
And there's a lot of, so if I keep saying it, it's because there's a lot of money at stake. My lords, you're right. My case is undisputed, there's only one meaning, and it should be given that meaning. And the further negotiations has no particular meaning. She goes over the page at 136, I think I can possibly take you on there. What matters in terms of objective construction is the ambivalence created by the categories, the logical possibilities as to undisputed, of which I said there is none, and the word negotiations is used in relation to undisputed in Resolution 4. While Sahara's case on this was extremely well put, both in writing and orally, in my judgment, it gave too much weight to the simple word undisputed and insufficient weight to the natural meaning of negotiations. She didn't seem to contemplate the ambiguities that lie very close to the surface in further negotiations. So she's taken the word undisputed, which says, oh, that's got an ambiguous meaning, and further negotiations, that's got only one meaning. She's just inverted the logical process, I'm afraid. And she says, negotiations has to be given a natural meaning if that is possible, and I've pointed out that it has all sorts of potential natural meanings, but one, in the light of what was happening, is that the parties had agreed what they had, but there might be a need for further negotiations as to when the payment would be made, and if the government of Cameroon came back putting a spanner in the works, well, they might need to do more. But that's undoing an agreement rather than making the agreement in any way dependent. It wouldn't have achieved the purpose which obviously would achieve of getting Sahara's bankers to free up the finance for the provision of free products. Because if it was not an agreement, then they would be most unlikely to comply. Then she says 137.
You note in passing to you that 136, she's not only, which is part of the resolution, but she's given undisputed and claims capital letters, which bear in the
Yes.
in the document.
We should give that it's a point I made earlier. I should have spotted it, but I haven't.
All right. 137.
137. Nor is it right to say the sentence of Resolution 4 presumes agreement on Sahara's liability on the basis that there would otherwise be no point in flexible payment terms. Resolution 4 perfectly sensibly covers both the fully agreed elements, principal and reconciled, and the undisputed elements. In context, it makes perfect sense for it to be read as for parties to convene Sahara to propose flexible payment terms, schedule, agreed, principal and reconciled, and further negotiations on the undisputed claims undisputed. Well, she's rewriting it. I would accept that that would be a way of reading it, but it's not the right way, given that undisputed has been stated out. And then she says, this then dovetails with the further admissible background, including the position of the government of Cameroon. It is agreed that there had been a long outstanding issue which the parties have been trying to resolve by now for years. There had been a number of reconciliation meetings in which Sahara had pressed for payment, and where Sahara had made clear that they were not persuaded that the claims fell within the boundaries of their contractual liability. There is the unlikelihood of Sahara, in the financial position it was in, agreeing to any liability that wasn't clearly established. Well, the problem with that is that it's precisely because Sahara was in that position that it would agree, because it was going to try and get the money from somebody else, from the government, from its principal shareholder. So rather than an unlikelihood, there is an overwhelming likelihood, I would suggest, that they would agree it to try and anything to free up money from the government.
You say that's not a finding of fact,
No.
that they were in fact unlikely to agree. It's,
No.
it's a finding of fact that they were in a parlous financial position, and then it's an inference that the judge has made from that.
Yes.
That
Which-
means that they were unlikely to.
Which she hasn't in any way investigated or explained why she thought it was unlikely. I can understand that if Shell agrees to something which is going to cost them a lot of money, then it's unlikely that they would agree to doing that. But it may be that they've got other reasons. But where Sahara don't have that comfortable position, and they've got to look to funding from the government, then there's no unlikelihood that they'll agree it's anything other than what will free up the money. And, importantly, free up the provision of products which were to be provided and financed by Sahara's banks. So everybody had the interest in getting an agreement done. Everybody had an agreement, an interest to get it done there and then, so as to free up the provision of products for sale within Cameroon.
I mean, what she seems to be saying in 138 and 139, the expression clearly established, which was not clearly established at the end of 138 and demonstrably due at 139, was that, as I understand it, what she's saying is everybody thought or knew that if something was clearly established or demonstrably due, the Cameroon government would pay it. But if it wasn't clearly established or demonstrably due, there's no reason to think that the Cameroon government would pay it.
Yes, except
Have
it
I misunderstood that?
It was clearly established that it was demonstrably due when they agreed that's undisputed.
Yeah, but I'm just trying to understand what the allegedly, or what is said to be the matrix that the judge is dealing with at 138. I'm misreading it.
No, I don't think your lordship is misreading it. Then 139, she says, at the same time, there's a number of bigger picture issues.
Where's the evidence to assuming that is contractual matrix rather than to interpretation? Where are the findings of fact to support those propositions that were set out in the video?
She set them out for. I'm not aware of any.
I understand everybody knew the last sentence of 139 that Sahara was looking to the government of Cameroon for support because of the fire and everything else.
Yeah.
But going beyond that to say the Cameroon government would pay if it's clearly established, but wouldn't pay if it wasn't.
Yeah,
is that?
That's not subject to any fight. There was no evidence from the government of Cameroon at all.
Well, it's not so much what the government of Cameroon thought. It's what was common understanding of both. If it's going to be matrix, it would have to be common understanding of both parties.
So you're right. And there was no, all that I think both parties knew was that the government of Cameroon would have to come up with the money. But nobody had to.
But the nuance of it would come up with the money if it was clearly established and demonstrably due, but not if it wasn't, is a nuance that you say isn't supported.
That's a nuance which is not supported by the findings made by the learned judge, or indeed it was never put to my witnesses. Indeed, it was put very specifically. You knew that the government of Cameroon was required to fund it.
And the judge, she is going on to say that the reason that counts against you is that this wasn't a claim which would have been regarded by Sahara as demonstrably due, because they had consistently rejected clause 26 as a basis for the claim.
That's right. Yeah. And if that had been written in as a comment section to on the box, right-hand box of undisputed claims, I wouldn't be here, but they didn't. So there we go. And then at this 139, a number of bigger picture issues. Firstly, the parties had cooperated and wanted to put themselves in a position where the relationship could continue. That's the SOPs, among other things. Specifically, Sahara had made clear that the issue was very pressing and that it wanted to reach a position where it could expect payment. It had something give to its new, now fractious banks. Then there is the fact that the parties knew the Cameroon government agreement would be needed for anything not demonstrably due. That there is no finding of that fact, otherwise than in that one paragraph. But particularly in the light of the financial crisis, Sahara was dependent on the government for support.
Well, that does purport to be a finding. You say that's a finding that wasn't open to her. Do you want the evidence?
Well,
I mean, it's a finding that the parties knew that.
yes, yes, it really wasn't open to her. There was no suggestion. Yes, I think you're right about that. But I do say it doesn't matter, because demonstrably due means not that they are fully argued out clause 26 and clause 8, but they just said undisputed, which is why I think I thought it didn't matter, because if they describe it as undisputed, then it's demonstrably due.
So you say, A, there was no evidence to support the finding that the parties knew that government agreement would be needed for anything not demonstrably due. And you then say, in any event, that there was an error in treating the position as being the undisputed amounts wouldn't be regarded as demonstrably due, because there had been a bill up until this point.
Yes, I mean,
They were recoverable on the basis of clause 26.
correct. Yes.
Is that the right way to analyse it?
I think, so on the first point, one would have to say that it was never pleaded that we knew that that was the position of the Cameroon government, and it was never put to any of our witnesses. So that is, I say it's a finding that wasn't open to her, but it doesn't really matter. Where we say it's undisputed in the agreement, then that is demonstrably due.
What does seem to be mentioned earlier in the judgment at 39 and 42 is a suggestion that Sahara was saying that extra charges not in the contract, like for could not be paid by Sahara without a court judgment for the
Yeah. That was never developed. That would be as a matter of Cameroon law, I think, and there was no evidence of that. I'm conscious that I've been going on, pushing on far too long. I think I can say, take you to 142. There is also the sense in positive undisputed as potentially kind of quantum, or at least the calculation of quantum in circumstances where one amplifies the context somewhat. It's apparent that what the meeting had apparently done was to go through the figures and attempt to reconcile them. See the title. Mr. Mattardi's evidence, finally what was being discussed was the numbers. Mr. Nzo's acceptance of the detailed documentation was to be submitted to the government of Cameroon, where it is clear from the genesis of the spreadsheets that they form the continuum in which figures had provided some time before in spreadsheet form with a variety of underlying documents which might need to be expected to go to quantum verification, and to one thing that the meeting did demonstrably achieve was some tweaks. I'm just not sure whether that takes it any further at all. And then finally, she refers at 143 to post-hearing, post-meeting correspondence, which is by which when Sahara said there was no agreement, and I don't think that really adds anything very much. And then at 144, she says, so far as the necessary fragmentary recollections of the meeting were concerned, no one seems to recall a debate on the clause 26 issue, yet on Sahara's account, Sonara had, during the course of the meeting, either seen the light or at least ceded a long-held position. The same can be said in reverse to Sonara's characterization, which involved an implausible definitional statement from Sahara. I reject Mrs Justice evidence on this point. That's the key point, the only key point. And then 145 we've already looked at.
Just pausing at 144 for a moment. Is accepting incremental interest question. Is this necessarily involve abandoning resistance to the claim being brought under clause 26. If I recall correctly, that the judge found it was within the foreseeable loss for breach of clause 8.
Yes. She said what?
Yeah.
Yes.
So they could have conceded that without conceding that clause 26 was an invalid basis for claim.
Yes. Absolutely right. Absolutely right. Yes, that's a good point about this. I'm conscious that I've been going on far too long. And then there's the finding about quick resolution, and then 146 halfway down. There was an agreement to disagree on penal charges. Well, there was an agreement to make a joint approach. There was an agreement that Sahara had become liable for incremental interest and FX in amounts which looked right, put the matter to the government of Cameroon, which might take a pragmatic view. There you go. And then come back to negotiate if there was no agreement by the government to pay or support the payment. To which I say exactly. It doesn't prevent the agreement, but it does explain why there might be further negotiations if the government of Cameroon come back and say, well.
No, but you don't agree that the agreement was that Sahara had become liable. The agreement was that you say that Sahara was liable.
What?
What the judge records here is there was an agreement that Sahara had become liable.
Yes, I think I should read Sahara.
Yes.
That really isn't like a white
No, I think she means Sahara.
No, she didn't.
She means
Oh
Sahara.
yes, actually, yes, I suppose. Yes, it does. Yes, you're absolutely
So
right.
that's why I don't think you do agree with this.
No, I don't. Yes, you're absolutely right.
This is her point, that she's that it seemed to me that her earlier finding that it's an agreement as to quantum modern liability is effectively the same thing as Sonara's contention that what it records is Sahara's liability for its payments.
Yes, which she rejected. Paragraph 144.
Well,
the implausible definitional statement from Sahara, and that was the post. And of course, it is implausible because Forex could never be a dispute between the banks and Sahara. Which the learned judge, I think, correctly identified at the last sentence of paragraph 141. So, if one reads 146 as the Lordship is positive, it makes no sense at all in the light of the last bit of 141 and findings of the conclusion of 144. I find it very difficult to extract the characteristic persuasive logical analysis that I would have expected. I find it very difficult to see that in this judgment. When undisputed means undisputed means undisputed, I think we should shut up. I haven't shown you the Hanyang and feed products case. Perhaps I can just I refer your lordships to it. It's in the authorities bundle at tab 5. There is, I think I can probably take you through to the Court of Appeal judgment. At page 6, well, in the bundle, it's page 68. Page 616. Report. The essential argument there was whether an agreement had been made on the 1st of February it was incomplete and there were other things to be resolved. And the other things were top, the right-hand column, first paragraph. On those facts found, the defence submitted and the judge found there was a binding contract on the 1st of February. Mr. Wilkinson, on behalf of the plaintiffs, attacked that finding. He advanced two main arguments. First, there was no agreement on the 1st of February because the parties had not yet agreed a number of important terms, including loading rate, rate of demurrage and dispatch, the rate and date of commencement of carrying charges. The correct inference, according to Mr. Wilkinson, is that the parties did not intend to be bound until those matters had been agreed. The second argument is a rather different one. And Mr. Justice Bingham held that, yep, they had agreed a deal on the 1st of February, whilst certain things still needed to be agreed. It didn't prevent them because they were masters of their own contractual fate. And we see the principles set out at page 71 of the bundle, 619 of the report, where Lord Justice Lloyd, as he then was, sets out the principles 1 to 6. And it's really 4, 5, and 6 that are relevant here. So one can have a concluded agreement, even though there are things which are yet to be agreed, and even though the parties anticipate that there will be such an agreement. And that's what that case decides. I hope I'm I guess slightly surprised that the learned judge didn't even refer to Appellant as being problems. Given the fact that I had addressed it quite extensively on it. But it's a lot of what it concludes about further negotiations runs absolutely counter to the principles in the Appellant and Defendant. So I'm conscious that I think I have made all of the submissions that I want to make. Thanks to the hard work of both of my juniors, our skeleton argument is rather better than I would usually use, but it does set out our case. I hope I've explained, as Lord Justice Phillips would say, undisputed means undisputed means undisputed. I've got some submissions to make on limitation. I don't know whether it would be more convenient for those to come later, but essentially my case is that when you have an acknowledgement which says these claims are undisputed, then that can be and should be a clearer acknowledgement under the Act. There's my print of the Act. It's section 29(5), which matters. It's the time bars fell in. Otherwise, falling. They fell in December 2019, January 2019, and November and February 2019.
I'm just trying to understand what this point matters for. It doesn't matter for the FX claims because they failed on
That's correct.
on the evidence.
That's correct.
It doesn't matter for category 2 penalty charges because on any view there wasn't an acknowledgement either as to liability or as to quantum.
It matters.
It only matters for incremental interest if you're wrong on ground 1.
Yes.
If you're right on that, there's no time bar problem in the first place.
Correct.
Is that right?
Correct.
And therefore we're examining this
For the purpose
on the hypothesis that the judge is right, that there was an agreement as to quantum but not liability, or
yes, it's
obviously if there wasn't an agreement as to either,
yes.
you're not going to get home on this. So
Well,
is that right?
I think that was pretty much underwriting the thoughts that my Lord Justice Phillips had in granting permission to appeal.
I'm just
And
trying
I
to
would say
understand the
yes,
premise
that's
on which I understand your argument is that if what was meant was, as the judge found, agreement as to quantum but not liability, that can be a sufficient acknowledgement, and that could save category 1, which is the only one it's relevant to. What I just wanted to understand was if the effect of the agreement is that it was just an agreement to agree altogether,
Yes.
can this save you?
There are 2 points that are made, both of them I think relatively short. One is that my learned friend says it's not a debt. I agree, it's not a debt, but it is a quantified pecuniary sum, because the parties have quantified it, and if on the learned judge's analysis, they've agreed what the sum is.
Yeah, but that's for it even to come within liquidated within the phrase, the agreement has got to be an agreement as to quantum.
Yes, and there was on the learned judge's analysis. So the only question.
So just come back to what I was putting to you earlier. Really, the only basis on which we're concerned with whether 29.5 bites or not is there was a binding agreement as to quantum, but not as to liability. Is that right?
Yes, and I would say there was an acknowledgement of the claim in the form of describing it as undisputed. And what the Limitation Act does not do is require overzealous analysis of what an acknowledgement is. I mean, we've got the judgment of Mr. Justice Carr in the Surrender case, which encapsulated I think the learned judge's reasoning. I mean,
But you don't say, do you, that if what undisputed means, taken together with it's going to be the subject matter of further negotiation, if that's what it means, it can be an acknowledgement.
yes, I do say that. I do. Because one can see that in the authorities there can be an acknowledgement of a debt or other liquidated sum, where the parties contemplate that there will be some further agreement to be reached. And yes, I do.
Yes, as to quantum, that's where liability is accepted, but there's to be some further discussion about quantum. Is that the case you're talking about? The letter to which there's a response saying we're surprised how high it is.
Yes, it's the solicitor's fees. Yes,
That's treated as not disputing liability for the amount.
That's fair enough.
But if the document on its true construction is a dispute both as to liability and as to quantum, you still say it can act to acknowledgement for section 29.5 too?
When it's described as undisputed, I say that is an acknowledgement of a claim. But it's a short point. But one is, I would of course accept that Mr. Justice Carr in Surrender, which is at tab 3, held that there has to be an acknowledgement of liability. This was a case where there was a set-off. You will remember there was a set-off where the would-be debtor accepted the set-off against the claim of a given amount, but no further. And Mr. Justice Carr was concerned with whether agreeing a set-off amounted to an acknowledgement of the claim which was being set off. And so it was a rather more discrete area of investigation. And he says at page 30 of the authorities bundle, page 573, at A, he says, I deal first with the question of acknowledgement. To acknowledge a claim as a matter of ordinary English signifies an admission that it is due. Not sure about that, but I think it's fair to say that that's the way that he proceeded. And then he cites good parity is not before your lordship.
Well, the only realistic alternative is that it's acknowledgement that a claim has been made.
Yes,
And I don't think you suggest that.
I don't suggest that. No. But I do say when it's undisputed, it's that one shouldn't start to over-analyse the agreement that is made. Is pretty much all I'm saying, but that's not what Section 29.5 is about. One can see just at the between C and D, the line beginning the injustices which the statute would work. The basis of the statute had been to free debtors from liability after the limitation period expired, because long dormant claims have often more of cruelty than of justice in them, by Chief Justice Best. Long dormant claims, and one in Mr. Justice, His Honour Judge Ruston said, you've got to look and see what is the Limitation Act actually about. It's trying to protect the defendants to claims that have long since been dormant. That's not the case in this case, and one shouldn't therefore strive overzealously to read uncontested or undisputed as amounting to anything other than the acknowledgement of the claim. Then, interestingly, one sees between E and F, where he talks about the old form of limitation, which required a promise to pay, so that the action on then became an action on the promise. And he says in a large number of decisions, the courts accordingly considered, often on highly artificial grounds, whether or not a promise to pay could be implied from the words employed by generations of shifty debtors. To quote Lord Sumner and Spencer, the upshot was that almost anything short of a denial of liability was held capable of implying a promise to pay. But if the statement was altogether inconsistent with the implication of such a promise, then the acknowledgement was held to be insufficient. And that's why I say what one really needs to see is something which is akin to a denial of liability. And you don't get that with the present joint report. But then he goes on to say, long line of authority was then given to statutory effect for the Tenterden's Act, and it removed the promise. It says at G, although the words weren't the alternative, they continue to be construed to mean an acknowledgement which implied a promise to pay. Section 23.4 of the Limitation Act 1939 omits the words or promise, and it's now clear that common ground that an implied promise to pay is no longer required. It may be said it's no longer required, but it may be that it still underlies the basic point. He then goes on to say at page 32, the passage side marked, there must be an acknowledgement of the indebtedness and the legal liability, and I would accept that that's what he decided. The learned judge followed that, but what I do say is that in our particular case, when there is an acknowledgement that a sum is undisputed, two sums are undisputed, then that is enough, even if upon a rigorous exegesis of what has been agreed, undisputed means disputed. Because I've now gone on far too long. I think
That clock's a little bit fast, but
I'm
we're approaching 1 o'clock.
yes, I don't really want to weary your lordship very much further on the limitation. It's still worth 20 million, which is quite a lot of money. But if your lordship could give me after the short adjournment, I will, I hope, distill my submissions on limitation.
Very good. All right, 2 o'clock.